Welcome to the Explainer. Okay, let's dive right into this. Have you ever signed a piece of paper, shaken hands on a deal, and thought to yourself, well, that's it, we've got an ironclad contract? It's a super common misconception that as long as two people agree to something and put it in writing, boom, it's legally binding. But the truth is actually way more complicated and honestly, a whole lot more fascinating. We're going to explore the hidden boundaries of contract law together and break down exactly why some deals are literally dead on arrival. So think about this. Can you legally buy the moon or the ocean? Now, I know it sounds like a totally absurd hypothetical, but it perfectly hits the nail on the head for our core concept today. You could sit down and draft a beautiful 50-page contract to sell the moon to your neighbor. You could put signatures on it, stamp it with a fancy wax seal, the whole shebang. But it wouldn't mean a thing. Why? Because for a contract to actually exist in the eyes of the law, it absolutely must be both legally and physically possible to execute. And believe me, it gets even weirder than trying to buy real estate in outer space. In this explainer, we're going to figure out exactly what a dead cow, a partnership in a brothel, and a local hairdresser named Zaza all have in common when we're talking about the limits of contract law. These real-world case studies are pretty wild, and they're going to completely change how you view everyday agreements. Here's our roadmap for today. 1. The rule of possibility. 2. When the law says no. 3. Restraint of trade and gambling. 4. The price of illegality. 5. When reality says no. And 6. Nailing down the details.
Starting with Section 1, the rule of possibility, the two pillars of a valid deal.
So, a contract's very existence relies entirely on two foundational pillars. If either of these crumbles, your contract simply does not exist. First up, we've got legal possibility. Basically, is the agreement and its rights and duties actually permitted by common or statutory law? If the law forbids it, it's illegal. Simple as that. Then we have physical possibility. Can this objectively be done in the real world? Failing either of these tests doesn't just make a contract weak, it means the contract is void from the absolute start. It's essentially a legal ghost. Which brings us to Section 2, when the law says no, good morals and public policy. Imagine society itself acting as a bouncer at the door of contract law, deciding which deals get in and which get tossed out on the street. This is the concept of public policy. The Supreme Court of Appeal has established a massive precedent here. Public policy isn't just some vague, fuzzy feeling. It derives directly from the Constitution's founding values. We're talking human dignity, equality, and the advancement of human rights. If a contract's term violates these constitutional values, it's contrary to public policy, and that bouncer says, absolutely not. The court will just refuse to enforce it. So what exactly does a rejected contract look like? Well, you absolutely cannot enforce a contract where someone agrees not to report a crime to the police. That thwarts the administration of justice. You obviously can't contract someone to commit a crime or a delict, like, say, defrauding an insurance company. You can't make a valid deal to supply military goods to an enemy state during wartime. And you definitely can't radically restrain a person's freedom to participate in legal transactions, like forcing someone to agree that they'll never accept a future inheritance. Every single one of these, totally void.
Moving on to Section 3, restraint of trade and gambling, freedom versus fairness.
Now, these are two really fascinating edge cases where the law has to carefully balance personal freedom against the broader public interest. Let's look at restraint of trade. Say Zaza sells her wildly popular hair salon to Vusi. Vusi is paying real money for Zaza's great reputation, so he makes her sign a contract saying she won't open a competing salon in the same city for 2 years. Courts generally view this as a reasonable restraint. It protects a legally recognizable interest, the business goodwill Vusi just bought. But what if an employer tries to use a contract to stop an ex-employee from using their own basic everyday skills in the labor market, just to crush competition? That's an unreasonable restraint. It violates public policy, and the courts will strike it right down. Then we have gambling. Historically, the law tried to outright prohibit gambling contracts because they were seen as encouraging wastefulness. But, as the government realized prohibition wasn't actually stopping anyone, they shifted to regulation, like the Lotteries Act. Today, if you gamble through a licensed, regulated activity, your winnings are fully enforceable in court. But what if you make a massive, unregulated back-alley bet with a friend? The law is absolutely not going to help you collect that debt in court, but it does recognize it as a natural obligation. That basically means if your friend actually pays up, they can't suddenly change their mind and sue you to get their money back.
That takes us to Section 4, the price of illegality, void deals and tainted money.
Okay, so what actually happens when you brazenly ignore the rules of legal possibility? The consequences are severe, and they come with some pretty intimidating legal Latin. Ex turpi causa non oritur actio. This is the ultimate unbreakable rule of unlawful contracts. It is absolute. The courts never, ever relax it.
Translated into plain English, it means no action arises from a shameful cause. If you enter into a contract that's illegal or unlawful, the court will simply refuse to recognize its existence. None of the parties acquire any enforceable rights whatsoever. Think about it. If you hire a hitman, pay him up front, and he just doesn't do the job, you can't exactly sue him for breach of contract, right? The court is going to slam the door right in your face.
But what about getting your money back? That brings us to our second heavy-hitting piece of Latin for the day. In pari delicto potior is conditio possidentis.
We call this the par delictum rule. It means when there is equal guilt, the possessor is in the stronger position. Let's use a classic example. Joe sells unpolished diamonds to Piet. Now that's a statutory crime if you don't have a license. Piet hands Joe a briefcase full of cash. Joe takes the cash and then flat out refuses to hand over the diamonds. Because both parties are equally guilty of entering this illegal contract, the law just washes its hands of the whole thing and leaves things exactly as they are. Joe is in possession of the cash, so he's in the stronger position. Piet can't claim the diamonds, he can't claim damages, and he can't even claim his money back for unjustified enrichment. He's just out of luck. Let's see how this builds into complex networks of contracts. Remember that brothel teaser from the start? Say Kylie and Dudu sign a partnership agreement to run an illegal brothel. That contract is contrary to good morals, so yep, it's void. But what if they get a separate loan from a guy named Don to build the facility? Is Don's loan agreement valid? Well, indirect enforcement of the illegal brothel contract is banned, but Don's loan is a separate, connected transaction. The court has to look closely at the causal connection. If the loan actively encourages the unlawful act, it might be condemned, or it might be voidable at the choice of the innocent party, which in this case would be Don.
Section 5. When reality says no. Physical impossibility. All right, we are leaving the theoretical realm of the law and entering the physical world. This is the second major pillar of contractual possibility. Fondi agrees to sell a specific cow to Paul. They sign all the papers. But completely unbeknownst to both of them, at the exact moment they're signing the contract, Fondi's cow has already died in the pasture. This is objective impossibility, because it is physically impossible for anyone on Earth to deliver a living cow that is already dead. No valid contract ever arises. It's totally void from the start.
So the crucial takeaway here is the massive legal difference between objective and subjective impossibility. Objective impossibility, like the dead cow, where it's literally impossible for anyone anywhere to perform, voids the contract entirely. But subjective impossibility, that's when performance is just really inconvenient or impossible for you specifically. For instance, you sign a contract to buy a house, but you personally just can't secure a bank loan. It's not objectively impossible to buy the house, you just don't have the cash. In that case, the contract is perfectly valid, and your failure to pay is just a standard breach of contract.
Section 6. Nailing down the details. Certainty of performance.
We've got one final hurdle to clear. A contract is only possible if everyone actually knows exactly what is being traded. Performance has to be determined or ascertainable. Look at how courts categorize these obligations. If you agree to buy a specific painting, let's say Van Gogh's The Potato Eaters, that's a simple or facultative obligation. The performance is completely determined right from day one. But what if you agree to buy one horse from a specified group of 3? That's an alternative obligation. The specific horse isn't determined yet, but it is ascertainable because you have a clear formula, a choice to figure it out. Once that choice is made, it locks in, and you must deliver that exact horse. And finally, we have the generic obligation, which is huge in agriculture and manufacturing. You aren't buying a specific item. You're buying from a category or a genus. To make this valid, you've got to define the commodity, like mealies, establish the method of selection, like, say, 100 tons, and identify who makes the selection. Now, here is the absolute coolest legal quirk about this. You can never claim impossibility of performance for a generic item. If your silo tragically burns down, you still owe 100 tons of mealies because the entire legal category of mealies hasn't gone extinct. You just have to go buy them somewhere else. Which brings us to the end of our explainer. The next time you shake hands on a deal, take a second to ask yourself, is this actually legally and physically possible? Because the law of contract isn't just about what you agree to, it's about what reality and society will actually allow you to do. So, look at your own agreements. Are any of them legally dead on arrival? Thanks for exploring this with me, and keep questioning the fine print.